of the benefits of being a Women's Rights Network member is taking part in our weekly Zoom conversations and putting your questions to a wide range of fascinating guests. This Zoom with Michael Foran is our most attended to date, so definitely worth a listen. Enjoy.
So, hi, Michael. Welcome. For those who may not be on Twitter or may not know you, you're a lecturer in constitutional law at Glasgow University, moving there from Strathclyde. I was interested to see that, with a particular focus on the rule of law and legal equality. I don't think we need to go into the details of exactly what legal equality means, but you're certainly an equalities expert, probably, you would say.
Yeah, I hopefully say that. Yeah.
Okay. So the first thing I kind of like to know is, I mean, you're not from Glasgow. I know that for sure. Um, you're not even from those shores. What, so not necessarily what took you to Glasgow, but what brought you into this debate that we're having about sex and gender? If you could, being politely calling it a debate.
Yeah, I suppose I'll just start by saying thank you so much for having me. It's a real honor and a privilege. And I've got to say, I hope that I've met a few people who are part of this network already at different events and things. And every time I do, it's been a wonderful experience. So I'm really, really glad to be
That's
here. Thank
kind
you for
of
the
you.
invitation.
Thank
So what got me into the topic, the debate, all of that was it really was by accident. I am, like you say, predominantly a constitutional lawyer, but my area of interest in constitutional law is things like equality and non-discrimination. And so I'd been following some of the developments within anti-discrimination law around sex and gender identity. So the Forstater case, the Bell case, things like that were happening. But I hadn't really dipped my toes into the waters of that front because I was writing other things in different areas. And I really, I would have had a very typical academic interest, not particularly politically engaged on that front. And effectively, what brought me into this debate was I wrote a blog post thinking I was doing a very academic thing. I'd seen a case that had just been decided a week prior, the Lady Haldane judgment in one of the first of the Forum in Scotland cases that unequivocally said that having a gender recognition certificate changed your sex for the purposes of the Equality Act. And I'd been aware living in Scotland that there'd been quite a lot of discussion about the legal effect of a gender recognition certificate in the run-up to the Gender Recognition Reform Bill. And what the courts were saying was not exactly aligned with what the Scottish government had been saying when it had been presenting its defence of the Gender Recognition Reform Bill. They were saying self-identification, self-ID would have no impact on the Equality Act. They even put that on the face of the bill. They said it's just, minor administrative change, no issues here. And then that judgment dropped, and I saw probably something that few people in the legal world are kind of at the cross section where I am, which is constitutional law, specifically Scottish devolution, and equality law. And so I saw the potential for the use of a Section 35 order in the Scotland Act, where the UK government could veto or block a bill that had been passed by the Scottish Parliament on the grounds that it would interfere with the operation of reserved matters. And in this area, that's the Equality Act. That's equality law, which is confined to Westminster. So I posited this. I said, look, there's this judgment, there's this background power here in the Scotland Act, and there's a potential for the UK government to veto this bill if it's passed. And that exploded. I wasn't expecting the blog post to get the kind of traction that it got, but it did. It got a lot of attention. And then it fed into the political debate around what to do in the aftermath of the Gender Recognition Reform Bill passing. And, I just want to say, like there's a narrative that you could say here that this was a legal argument that had a important role to play in stopping self-ID in Scotland. But that legal argument wouldn't have been in any way effective if there hadn't been the kind of grassroots feminist movement all across the United Kingdom that had been making this a politically salient issue and made it politically viable. I personally don't think that the UK government for a moment would have contemplated making a Section 35 order if there hadn't been that grassroots movement. But I think the grassroots movement needed the legal tools to get them over the line on this. And that's what I provided with some of the commentary and analysis that I did on that. And then from there, I've kind of just gotten hooked, both in terms of a realization of the importance of this issue, the salience of it for politics. My own ignorance on that up until that point was pretty stark. But also, the more I thought about it, the more I saw really interesting, serious, legal, knotty problems that we hadn't really seen in equality or non-discrimination law for a while. We kind of had a pretty settled understanding about all of these things like race discrimination and stuff like that. But this stuff here, this is both extremely important and also, I think, interesting from a lawyer's perspective.
Well, we're very great that your interest was piqued. Was it something, back to the start when you read, was in the news, that was there something that immediately came to your mind? Or did you have to go away and have a look and see would a Section 35 allow this or not? Or are you such an expert that you immediately thought, well, that contradicts Section 35?
I had to think about it. I mean, the Section 35 power had never been used before. So what we were really relying on was kind of background legal constitutional principles. There was no case law on this. There wasn't a judge saying, here's how this power is supposed to work. So I had to think about it, and it was complicated. It was knotty. And I put forward initially an argument that said this was a plausible thing. It could happen. And then as things happen, you kick off a conversation among lawyers on social media, and I became more convinced that this was something that really could be established. So I wrote a much longer piece on that kind of set out the case for making the Section 35 order, which was then picked up and read by Alistair Jack, who's the Secretary of State for Scotland at the time. And he then relied on that to justify making that decision. And even then, when the decision was made, I was thinking, have I just destroyed my career? Because if this gets legally challenged, which it will, and it goes before a court and a court says there was no foundation for making this order, whoever advised you that this was a good idea is clearly an idiot, doesn't know what they're talking about. And so I was very worried for a few months as things were going through the court system. But thankfully, there was a legal challenge to this. The Scottish government's challenged the use of that power. They said that in this case, it was inappropriate and unlawful for the UK government to exercise that power. And the same judge, Lady Haldane, ruled in this case that the Scottish government's argument was unfounded, that the UK government did have the legal power to make this order in this case because the Gender Recognition Reform Bill really would affect the Equality Act and by extension the rights of women and girls.
It's not stopping them doing it by doing what they want by stealth. But there was that nail in the sand, and as you said, it's given us, we've got up another rung on the ladder with that. With every court case comes along, there's another rung to get up. And I know the Wales group are working extraordinarily hard fighting what the Senate is trying to introduce, and also in Northern Ireland, the wonderful women out there are working really hard, tremendously well. And at the moment, they're getting, they are getting some results. Well, people talking to them as a result for us at the moment.
I mean, my view is that, from I think the last 2 years, really the last year, I think the conversation has shifted extraordinarily in what is polite, respectable company. It is now acceptable for people to voice gender critical views, sex realist views. These are taken seriously in the workplace. Clearly not in all workplaces. We've got a lot of work to do to ensure that the anti-discrimination law that we have is actually enforced. But things have shifted dramatically over the last 2 years, I think. And I think a lot of that has to do with what networks like this have been doing. You are the ones who are making this the kind of viewpoint and opinion that is the ordinary view that your neighbor has, that your friends at work have. Like you're demystifying what the I suppose the kind of bigoted or prejudiced views that some people have, that we've seen in some of these tribunal cases against people like Joe Phoenix or Maya Forstater.
We have indeed. It is an uphill struggle, but but we are getting there. And like you, watching from the sidelines before you got involved, not really realizing the full extent of potential impacts on this. That's what we're battling, because a lot of people out there aren't thinking beyond calling somebody she or him. That's where they think it ends, but it's as we know, it's a lot more than that. I'm not saying that was the extent of your concern about it beforehand. And so keeping on Scotland, of course, that essentially has led us to what happened at the Supreme Court and the For Women Scotland challenge there on what is a woman, which is, quite bizarre, but also quite wonderful. So I know that I saw you in court listening away to that. I could
Yes, I was very lucky to be there.
It was quite an experience. No, we've not got a judgment yet on that. Do you think that's going to come out in 2025?
Oh, it would absolutely be out in 2025. My guess is that it will be within the next 2 or 3 months. Normally we're talking about 3 to 6 months from the date of the decision, or from the date of the hearing, before the court will issue a judgment. So I have no doubt it'll be in 2025. It will not be 2026 by the time we get this judgment. And it really can't be, because I'm writing a book on this and this judgment needs to drop before I could finish the book. So the sooner the better.
You'll have to give your advance back. What's going to be the impact? I mean, obviously we all hope for the result, which is woman as adult human female, and no, don't be silly. And because a lot of the discussion and argument, particularly on the second day and around what's a lesbian and when's a lesbian and when's she not, it did almost descend to farce in there. Supposing it goes against us, what's the implications there, and what's our next step? What do you think?
So at that point, I should probably say that my view is that the Four in Scotland are going to win this case. Having seen been in the court, having seen the arguments, having seen how the court, the bench, the judges responded to the arguments, and I think in particular to the arguments about lesbians. The Scottish lesbians didn't have oral argument that day, but their written argument, which was presented by Karen Monaghan, who is, she writes the textbook on discrimination. She's extremely well respected by the bench. Her interventions clearly were in the forefront of the mind of the judges throughout the entirety of the hearing, but particularly on the second day, I think. So my view is that the likelihood is that For Women Scotland will have succeeded here, but presuming that they haven't, and the court effectively upholds what the inner house of the Court of Session held, the previous judgment that's on appeal here. The first thing that we can say about that is that it will make the Equality Act a mess. It'll be an extremely difficult piece of legislation to interpret. It'll be a very, very hard piece of legislation to apply as a service provider, as someone who's just, operating a service out in the world, because whether or not someone counts as a woman will depend on whether they are in possession of a secret certificate. And that's going to create a whole host of issues for the implementation and the operation of the Equality Act. But I suppose there's a few things to say about that. I mean, the first thing is that even if having a gender recognition certificate changes your sex for the purposes of the Equality Act, that doesn't mean that someone with a certificate is entitled by right to access single-sex spaces of the opposite natal biological sex, because there are exceptions in the Equality Act that allow for that. They allow for people to be excluded on the basis of either sex or gender reassignment. And so having a certificate, what it would do, according to the Court of Session, is that it would shift you from having no presumptive right at all to access those spaces into having what they refer to as a prima facie right, which is an on first blush right, like a presumption that you have an entitlement. And then you'd have to think a bit more seriously about whether or not that entitlement actually cashes itself out. And that will depend on whether or not the rights of other people are engaged. And for virtually all single-sex spaces, the rights of women are engaged. Mm-hmm. And so there will be complex law that would have to resolve that. But the exceptions would still be there. You'd still be able to rely on those exceptions in the provision of services. You wouldn't be able to rely on those exceptions in terms of women-only associations. So like lesbian working groups or support networks that are not services,
Women's
or the
Rights
Women's Rights Network, exactly. You wouldn't be able to do that. And that really occupied the mind of the court throughout the second day. They were very acutely aware that this was a particular problem because it interferes with the right to freedom of association. There was one point where Ruth Crawford, the barrister for the Scottish government, who was just doing her job, but mm-hmm. she was presenting some pretty strange arguments. I think she said at one point that a lesbian-only group could be a gender-critical lesbian group. It could associate on the basis of being both lesbian and gender-critical. And there were problems with that because that's not really how the tests work. It's about single mm-hmm. characteristics rather than combined. But there was a point where Lady Simler, one of the Supreme Court judges who has the most expertise in equality and employment law, she just asked, almost in surprise, but they couldn't just associate as lesbians. Why can't they just associate as lesbians? So I think there are implications here. Like there are things at stake in this case. A win would clarify the Equality Act tremendously. A mm-hmm. loss would create a mess for the Equality Act, but it wouldn't make it impossible for you to operate single-sex services. It would make it impossible for you to operate women-only associations. And I think that's a pretty big human rights interference. Mm-hmm. And so there's a lot at stake here. And I think really what would happen in practical terms is if Forum in Scotland lose, the political campaign to ensure a legislative amendment or some kind of change in Parliament gets mm-hmm. kicked off. Now, whether the current Labour government has any appetite for that or not, I think is a separate issue.
Yes, they don't have appetite for a lot of things at the moment. That leads me on to a question about the Gender Recognition Act. So my understanding, it was introduced in response to our requirements to comply with European law.
Yeah, that's correct.
And it was about ensuring equality for those that wanted to consider themselves to be of the opposite sex or felt they were the opposite sex. But as we know, there was no requirement to have any surgery or medical.
Yeah, and I'm not even sure if it would be equality would be the best way of framing this. So I suppose the first thing to say is that it was introduced in order for us to remain within our obligations under the European Convention of Human Rights, which is different from the European Union. So Brexit would have resulted in the UK leaving the European Union, but not the European Convention on Human Rights. And that convention has been the touchstone of basically all of the rights that we would rely on in court for things like freedom of association for lesbians or women's sex-based rights. An awful lot of those rights are underpinned by the European Convention on Human Rights, and also things that we would associate with strong social welfare and other things like that. But the obligation that arose in relation to gender recognition came as a result of a combination of two legal obligations. One was to respect the right to marry, which is superfluous now because there's equal marriage. But the other is not superfluous, which was the right to a private life. And the European Court of Human Rights has interpreted the right to a private life to include a right of initially post-operative transsexuals to be recognized in domestic law as having changed sex in some way. And this correlates with recognition on state documentation. and then has effectively said anything else beyond state documentation, like passports or birth certificates or things like that, that's up to individual member states to strike the right balance on. So the obligation that's come in under the European human rights law is to say you have to have some system of gender recognition, but the way that actually works out within your domestic framework, how you balance the competing rights, is up to you. And the courts have then taken that forward over the subsequent years to expand that to go beyond merely being required to do this for post-operative transsexuals. Now it says that you cannot lock the requirement, or that you cannot lock these entitlements behind either, in one case, surgeries that sterilize you, and in another case, just surgeries.
Mm-hmm.
And ordinarily, under European human rights law, those cases only bind the states that are parties to them. So the UK is bound by the Goodwin decision, but not these other decisions. But the Human Rights Act places obligations on domestic courts to keep pace with European Court of Human Rights jurisprudence. So there's a pretty strong domestic human rights law principle that will be pushing quite heavily in favor of the idea that the UK as a legislature, as a state, is required to have something like this. And if we don't have it in the form of the Gender Recognition Act, where we will have specific carve-outs written into the legal framework, if that's not there, the courts will likely fill that gap. And, that can go one of two ways. The courts can either expand these rights into areas that the Gender Recognition Act never intended them to be expanded into, or it can limit them. And it really just depends on whether we want to roll that dice, what the kind of legal consequences might be for something like repeal of the Gender Recognition Act, which I know is an issue of particular importance to a lot of people in these conversations.
Yeah. So tell me then, or give me some examples, because sometimes we struggle, and is where it comes from, is given that we've same-sex marriage, what is it that having a GRC gives somebody, other than, as it's often perceived, just access to women's spaces and the battle that we're having?
Yeah.
What else does it do for somebody?
Well, I'm not even sure that it does that. I mean, the thing that's currently up for debate in this case law, I mean, we have a settled law in the Forum in Scotland case before the Supreme Court, is that having a gender recognition certificate gives you a presumptive entitlement that could be overridden by competing considerations. So it might not even give you that entitlement. But, parking the spaces question aside, which was really kind of peripheral to what the European courts were considering, there were two things that...
Yes, because they didn't consider women.
No, well, they considered women to be a certain inconvenience. The court in Goodwin had said that society can be expected to take on the burden of a certain inconvenience for having laws in this area that change the meaning of sex. And so you can see how that may not have aged very well and may not have been pretty good at the time either. But I think that the reason why the court framed it as such was that it didn't anticipate there being a direct link or obligation from the Goodwin case to something like access to spaces. The court said this was up for member states to decide how they were going to strike that balance. What the court said is that you have to have some system that allows people to change their birth certificates. And the consequence of changing your birth certificate could be very narrowly defined, or it can be very broadly defined. And one of the things that we've seen in the discussions politically around this is that proponents of what we describe in this kind of conversation as trans rights, they seem to oscillate between whether or not a gender recognition certificate is just a piece of paper that allows people to live in dignity without having to die without the right name or the right gender identity according to that person, or it being an extremely important document that gives you rights all across the legal sphere. What we know for certain is that a gender recognition certificate changes your legal status for the purposes that the Gender Recognition Act applies to. And we have a kind of open-ended idea about what that might be. We know what it doesn't apply to. It doesn't apply to sex-specific crime. It doesn't apply to inheritance. There's areas where it won't apply. And the only areas where it could possibly apply is in areas where the law is already making a distinction between men and women. If the law is not making a distinction between men and women, this certificate doesn't do anything. It's just something that makes people feel like their identity has been validated, and it allows them to get this document issued to them. But the legal consequence of having the document, in areas where the law is not distinguishing between men and women, is minimal. The problem, of course, is that when the law does distinguish between men and women, it's usually because doing so is a good idea to protect the rights of women. In the past, we would have distinguished between men and women for all sorts of illegitimate reasons. And those have gradually been chipped away as the feminist movement has won legal battle after legal battle, either legislatively or judicially. So what we're left with now is a set of areas where it's really complicated, because almost all of those times when we're drawing those distinctions is when it matters to draw those distinctions for women or for children in some contexts. And so basically the answer to what it does in addition to access to spaces is unclear outside of the specific context, because you'd have to do these kind of human rights analysis to think, would it really matter for maybe not access to spaces, but does it matter for background checks? Does it matter for whether or not someone is entitled to work in particular context? Does it matter for prisons? So all of these things are incorporating complex questions that have to be resolved almost on a case-by-case basis, which is a really bad way to run a system that's supposed to be hinging on the rights of individuals. But what it doesn't do, it doesn't automatically give you an entitlement to enter into opposite sex spaces. That's absolutely clear. We know
that, but unfortunately they don't
know
that. So that's really interesting. I'm going to give the members a chance to get some questions in. So Vicky, have you got some questions for Michael?
I've got hundreds of questions, so I don't think we're going to get through them all, unfortunately, but I'll do the best I can. So the first one is, Michael, we see on social media that people are often threatening to get you sacked. What does your employer, what's your relationship with your employer? Do they support you? Are they supportive?
They do, yes, they are. I think, there was a time at the start of all of this when there was a pretty adamant pushback from people. And then it kind of fizzled away after there was some very vocal senior members of my law school supporting me. And this tends to happen, people try and drum up a storm, and then, people who are in positions of authority step forward and say, this far but no further. You can say whatever you want on social media, but we're not punishing this person. We're not firing this person. And, I think, a similar thing happened a few months ago when there was a kind of concerted effort by, I don't think that many people, but they were pretty consistent in attempting to get either my law school or my university to investigate me for misconduct. They claimed that I was a danger to my students, etc., etc. And after a bit of kind of back and forth, the university was saying, we completely support you. Is there anything that we can do? And I was saying a public statement would be great. Eventually, they sent a letter to me signed by senior members of the university saying that my academic freedom is protected. And shockingly, after I published that and made it known that I was supported, these threats died away. People stopped trying to get me fired. It may happen again, but I've got that letter now. So I am supported, thankfully.
Right. And
what do your students feel?
Yeah.
I have some of the best students in the world. They're really fantastic. I suspect most of them have no idea about my involvement in this area. But when things were getting pretty bad last semester, a few months ago, I had to cancel one of my lectures because things were getting a little bit intense. And I got several emails from students reaching out and saying that they suspected it wasn't illness was the reason why I'd cancelled the lecture, and saying that they'd followed some of the stuff that had been happening, and they respected the work that I was doing. So that was a very heartening
That's great.
moment.
That's really good to hear.
First year undergraduate constitutional law student, fantastic.
Brilliant.
Yeah.
And how do you cope with the social media pressure and the abuse that you get on social media?
Not well. I think, I think I'm a lot better now. I mean, in the past, I used to have this real problem of thinking someone is wrong on the internet and it is my job individually to correct them. And then you'd get into this constant back and forth, and people would be making very personal comments, and it would be very upsetting. And I'm not saying that I'm perfect now, but I'm much more detached from this now. I'm much more able to say these are little demons in my phone, and I can just block and move on, which is much, much healthier for me than it has been in the past. And this is true because part of the tension with maybe some of the stuff that I say is that because I try as far as I can, I made a conscious choice at the start of this to that the real gap in this market, or the gap in this space, was someone who could just, as far as they can, neutrally describe the law and make it informative and combat misinformation, and try not to do too much in the way of campaigning or attempting to push for particular political solutions. And so that means that, sometimes I say things that people on the sex realist, the gender critical side really, really dislike. And I get a lot of attacks from people on that side. And I get a lot of attacks from people on the other side, because they also really, really don't like some of the things about the law. And this is a controversial, complex area of law. I could be wrong. Like, there's a lot of areas where there's real room for disagreement between lawyers, but often it's not. The attacks that I get are not framed from someone who has a different view of the relevant legal material. It's just someone who doesn't like the fact that I've said this thing about the law. And so, I've had to really try and distance myself from that. I think I'm getting better, but I'm not perfect. One of my big flaws, I think, is that I get too invested in online back and forths with people, which I think you need a little bit of to be willing to enter into this space, but you really can't let it take over your life. It'll destroy you, I think.
Yeah, well, lots of our members here are saying how somebody said that your clear and impartial analysis of the law has been very helpful and informative. So thank you for that.
That's very kind.
So the next question is, are all protected characteristics equal? And what happens when one takes precedence over the other?
That's a fantastic question. I think the rhetoric within equality lawyers is that they're all equal. But I think that's not true doctrinally as a matter of law, because disability is treated very differently from other protected characteristics. You cannot deny a Black person a right as a pilot, but you can tell a blind person that they're not allowed to be a pilot. The law just treats disability very differently. But equally, the law requires much more in the way of accommodations for people who are disabled. So disability is treated very differently. I think gender reassignment is treated very differently. And part of that's because we don't have as much case law on gender reassignment. So in practice, sometimes these characteristics take on the kind of social hue that is associated with them. And as particular characteristics become more and more salient, in practice, the experiences of people who have particular cognate groups within them changes. So, 10, 15 years ago, sexual orientation would have been a really controversial protected characteristic. And there would have been clashes between sexual orientation on the one hand and religion on the other hand. And things like race were becoming less contentious at the level of law. We kind of knew where all the law was on race, but in practice, it was difficult to get some of that out. Now, the real conflict is between gender reassignment and sex, and to an extent, philosophical belief, gender critical belief, or sex realist views. And there's two ways that you can think about this. One is to say that at one level, the law doesn't contemplate conflict because you can be discriminated against on the basis of your sex, and somebody else could also be discriminated against on the basis of gender reassignment, and you just run those claims individually to identify where whether or not someone has been subject to the kind of legal wrong that would result in a legal remedy. But in another sense entirely, there's exceptions carved out throughout the Equality Act that mean that there will be some times when the interests that are held by particular groups conflict. And in that case, the way in which that conflict is resolved is often by looking at very carefully calibrated provisions in the Equality Act, where Parliament contemplated what that conflict might look like and provided us with a solution. So, for example, gender reassignment and sex in the context of single-sex spaces, Parliament clearly contemplated that there would be a tension there, and it carved out clear exceptions that said you are allowed to discriminate on the basis of sex to exclude men from women's spaces, and you're allowed to discriminate on the basis of gender reassignment to exclude trans-identified people from women's spaces in some circumstances where that would be justified, whether they're male or female. And so the law has thought about those interests conflicting and has given relatively clear rules. Often the rules then kind of collapse into a proportionate means of achieving a legitimate aim test. But that's a pretty standard test within law. Lawyers are usually very good at being able to identify how that law operates. And it's only really when either activists who aren't fully trained as lawyers or lawyers who are more activists than they are lawyers get involved in a topic like this where suddenly that test becomes more complicated than it needs to be. So, for example, the idea that you would need to do a case-by-case assessment for every proportionality analysis is just not true. It's been rejected by the Supreme Court multiple times throughout the last 20 years. There's just a boatload of cases from the Supreme Court that says proportionality analysis does not require a case-by-case analysis, and yet some people are still arguing that it does. That's not a problem with the law, in my view. That's a problem with how the law is being misinterpreted, misrepresented. That's potentially disinformation being spread.
Great, thank you. The next question is, why do you think that Labour are resistant to clarifying that sex means biological sex in the Equality Act?
I think, I mean, a caveat by saying that I'm not a political scientist or a political analyst, so these are just kind of my gut feelings. They're not coming from any position of authority. But the vibe that I'm getting is that Labour sees the gender identity and sex issue as something that has ripped a hole through its party, that is extremely contentious, and for that reason does not want to address it, because addressing it would require disappointing one of those groups, whereas saying nothing disappoints both of them, but disappoints them in a minimal way. I think what Labour wants to do in the equality sphere is to return the conversation back to race relations and racial discrimination. It's floated ideas about expanding equality law in that area. And I think it's doing that because it feels more comfortable with its legacy on that area. And I think it feels more comfortable with getting any purported balancing that has to be done right. Because race discrimination is a pernicious, awful problem in our society, but it is not the kind of complex doctrinal problem where we're really having to balance the interests between competing groups in the way that conflicts between sexual orientation and religion would have done in the past, and sex and gender identity are doing now. So my sense, which again is coming from someone who isn't really an expert on this, is just that Labour doesn't feel comfortable in this space because it doesn't actually have an answer to it. And I don't think it really wants an answer to it. I think it wants to stay in the sphere of it not being their problem to fix. And that's going to create problems, I think, because that's not grown-up governance.
Sure, thank you. The next question is, will the 4 Women Scotland case affect the decision of various police forces to allow male officers, some with GRCs, to strip search women when the relevant act said it must be same-sex police officers doing that?
That's an absolutely fantastic question. The answer is going to be a little bit frustrating because yes and no. In one sense, this case doesn't have anything to do with the police network or the police guidance to strip searching cases, because PACE, the legislation that sets out that strip searches have to be conducted by members of the same sex, is a different piece of legislation. It's not the Equality Act. And so you wouldn't need to interpret the Equality Act in a particular way in order for you to interpret this legislation in a particular way. They're separate pieces of legislation. But it is relevant because the legal rules and principles that the Supreme Court is about to articulate, that's about to tell us how we are supposed to interpret the scope and the applicability of the Gender Recognition Act, in this case, in relation to the Equality Act, will have a direct applicability for how it's supposed to interpret the applicability of the Gender Recognition Act to PACE, which is that legislation that deals with strip searching. So if 4 Women Scotland win and the court says something like, the for all purposes provision in the Gender Recognition Act that alters a person's legal sex is not engaged in circumstances where the rights of others, particularly the rights of women, require sex to mean biological sex. Now, if that's what the court says, then these cases about strip searching are slam dunk cases. We know exactly how they would be resolved. If the court says it's a much more complicated picture, those cases become much more complicated. So there's a link between them in terms of the reasoning of what the court is going to do, but there's not a direct applicability. Like if you win on the Equality Act case, you could still get a police force saying, sure, that's fine for the Equality Act, but for PACE, the Gender Recognition Act really has to be the guiding force here, which is frustrating for a lot of people who I think want to have the kind of quick fix that solves all of this. And unfortunately, it's just too messy for that. We're in a very, very complicated legal system, and there is no quick fix. Even if, and it's a big if, repealing the Gender Recognition Act was going to stop the courts developing the law in this area, repealing the Gender Recognition Act is not, in my view, a quick fix anyway. It would take an awful lot of time to get that political traction to go there. So it's a really, really frustrating space to be in, because you get a small win here and then there's this other thing that causes almost exactly the same problem, and yet some people are pretending it's not the same problem. That's just, I think, the kind of exhaustion that comes along with being involved in a space where you have to make these little gains every so often to develop the law in this area to reflect what I think our underlying law has been trying to articulate since the Human Rights Act was introduced, since the Equality Act was introduced, which is to adequately respect the rights of, in particular, women.
Mm-hmm. Great, thank you. The next question is, in the NHS, the single-sex requirements clash with a lot of trans policies and are often in direct opposition. Mm-hmm. Which has legal precedent?
Policies have no legal precedent. If we have statutory obligations or legal obligations arising out of the Equality Act or some other legislation, Human Rights Act, for example, or regulations that say, for example, for schools, the law is unequivocal. You have to have separate changing rooms and toilets for males and females after a certain age. For a lot of employment contexts, you have to have appropriate facilities. And so there's a question about what counts as an appropriate facility. But if the law says that a mixed sex changing room is unlawfully discriminatory against women, that's it. There are no policies that can circumvent that. If the law says that you cannot do this, it's illegal for you to have one of those spaces. The fact that an employer has introduced a law or a policy that conflicts with the law just means that the employer is in breach of the law. Nothing further needs to be considered.
And can the employer be challenged on that, or would the individual have to? Would it have to be the individual that challenges that legally, or so? For instance, an organisation like ourselves, if we were aware of where an organisation's got a policy,
Mm-hmm.
an illegal policy.
It would depend. If the organization is a public body, if it's a government run I suppose if it's a government run body, you could bring a judicial review of some of their policies, which is what the charity Sex Matters is doing for the British Transport Police's strip searching policies. You can do that because British Transport Police is a public body. It's subject to the kind of rule that you'd be able to challenge on. If it's not a public body, then there's only really two claimants that could be brought in here. Either an individual claimant, like a nurse who works in the NHS, who's been affected by the policy and who wants to bring a challenge saying that the policy is unlawfully discriminatory against them or is unlawful for some other reason. Or the Equality and Human Rights Commission has an enforcement mechanism that allows them to bring challenges to policies. And they've done this in the past in relation to racial discriminatory policies and things like that. But obviously we're aware, I think, that the last few years have been quite turbulent for the Equality and Human Rights Commission. And I think their focus right now is on getting their guidance correct first before they start suing people for failing to act lawfully if the guidance itself isn't even there. You need to have the guidance from the HRC first, and then they will have an opportunity to do that. But the HRC hasn't been bringing that many of these kinds of claims. I think it really does fall down to the individuals to bring these claims now.
Okay, so what about publicly funded leisure centres that have only mixed sex changing facilities?
So if you're in receipt of public funds, that doesn't necessarily make you a public body. You could be subject to heightened obligations as a condition for being in receipt of these funds. So, for example, in Scotland, it's pretty often that the Scottish government would require you to have a trans inclusion policy before they would give you public money. That wouldn't make you a public body, so you wouldn't be able to launch that kind of claim. You'd need to be a government agency or a government body or something like that for a network or an organization to be able to bring a judicial review on that front. Otherwise, you're just going to need someone who's been affected by the policy, and then a legal challenge could be brought in under those circumstances.
Okay, thank you.
Mate, I hope we've got time for one more, which is, could you clarify the legality of asking to see a GRC to exclude men from women's only services?
That's a really good question, and I think it occupied a part of the Forum in Scotland hearing. And so I think it's important maybe to set out what I think the law is and what I think the Equality and Human Rights Commission says the law is, and how things may have gotten a bit confused in the Supreme Court. So there is a criminal prohibition in the Gender Recognition Act on disclosing the fact that somebody has a gender recognition certificate if you come across that information in an official capacity. There is no criminal prohibition on asking to see a gender recognition certificate. But the Equality and Human Rights Commission has issued guidance that says, because this carries with it a criminal prohibition for disclosure, it's our advice that you shouldn't be asking to see one of these certificates. And that was then kind of picked up in the oral argument in the Supreme Court, where the court just accepted that you can't really be asking for these certificates because the Equality and Human Rights Commission is telling you shouldn't be asking for these certificates. I don't think the court was saying that there's a legal prohibition or a criminal prohibition on asking. It's just in terms of the practicalities of how an organization would be operating, they shouldn't be asking for these certificates. And then that led into the court itself very clearly recognizing that if you're not supposed to be asking for these certificates, they can't be the thing that is the key to getting access to additional rights. So I think the court understood that, but I can understand how people who are watching the hearing was listening to the court saying, and you can't ask for a gender recognition certificate, and people were thinking, yes, you can, of course you can. I've had this whole thing where people have been telling me that you can. So I went back and listened to it, and it's pretty clear that what's happening here is Aidan O'Neill, the barrister who represented Forum in Scotland, quoted the guidance from the Equality and Human Rights Commission and their submissions and said, for practical purposes, you can't ask for one of these certificates because it carries with it legal consequences for messing up after you've asked for it. If you get that information in an official capacity, it's going to cause problems. But in terms of people who'd like to know what the law is on that specific question, there's no criminal prohibition on asking. It's just that if you do ask and you get that information, you need to be very careful what you do with that information.
Great, thank you. Heather, I'm going to hand back to you because I think we've almost come to the end.
Great, thanks. It's really interesting, Michael, and I am not surprised that your lectures are so well attended as you report, because that's been really good. Now you're talking to a number of women here, and I think probably every one of us has a PhD in the subject of sex versus gender, it to be such a thing, because we've all, we've learned so much, we've read, devoured, and you have added to that this evening. I think it's been really good. It's been really interesting. I think we will, Vicky, send Michael the chat, because there's lots of very lovely comments that are in the chat, and I think that will help you in the moments when you think, what the hell am I doing this for?
That's very sweet. Thank you so much for having me. It's been a real joy. I'd love to do one of these. I don't know if you do these with repeat guests, but you ever want me back?
Yes, we do. We will have you back. And just before you go, I think I confirmed that you are most well attended Zoom. There is, for those watching, that we've got a breakout room. There are more women in the breakout room watching from a different location. So it's more than the number that you see here. And so you have taken the title from Andrew Doyle.
Good.
And I'm just waiting to see, what woman do we need to have to break the male record?
I think the male record needs to be broken. I don't think a man should be holding the record for.
Well, you need, next time you see J.K. Rowling, you need to tell her that she come, because I can't imagine.
Oh yeah, because we're so tight. We're like really good friends.
We've had the most fabulous women and people on, and we do a very different one next week, to tell everybody. We've got a French lawyer who's coming to talk to us about the Pellico case. So still we're staying on the theme of law, but a very different angle on it. There is just no end to the issues that women are facing. And I don't know whether to be glad that all this is getting so much sunlight at the moment, but or it's just dreadful things happening everywhere.
Very depressing. But yeah. I think it is good that this is it. Otherwise, this just kind of, it lives in the darkness, and you don't want that.
It does, and women have lived in the darkness, and so many still are. So we're trying to shine some light. Thank you very much, Michael, for joining us. Thank you, everybody, for attending. Those that have got your cameras on, give Michael a silent round of applause for that. We really appreciate it, and we will get you back. We'll maybe get you when we've got the results of the Forum in Scotland case. That might
sounds
be
like a great idea
to get you back. All right. Thank you very much, and good night, everybody. Thank you for joining. See you soon.
Bye, everyone. Thank you for joining.
If you enjoyed listening to this podcast, head over to womensrights.network/WRN-podcast to listen, download, and subscribe to more great episodes. And if you'd like to join us, go to womensrights.network/join-WRN.